applicant in this bail application. The facts set out herein, save where the contrary is indicated, fall within my own personal knowledge and are, to the best of my knowledge and belief, true and correct. Legal submissions made in this affidavit are done on the advice of my legal representatives, obtained during the course of consultation. The charges. I have been informed that I would for now be formally charged with 3 charges of fraud in this division of the Honourable Court. In terms of the provisions of Section 60, 11B of the Criminal Procedure Act 51 of 1977 as amended, an offence referred to in Schedule 1 and the accused has previously been convicted of an offence referred to in Schedule 1 falls within the ambit of Schedule 5 of the Criminal Procedure Act. I am therefore obliged to satisfy this Honourable Court that the interests of justice permit my release on bail. I will elaborate hereon in the paragraphs hereunder. Personal circumstances. I was born on 24 June 1969 and am thus 56 years old. My identity number is 6906240182081. I am a South African citizen. I have resided in the Republic of South Africa my entire life. I have been resident at 1402 Pebble Creek Estate, Greenstone Hill, Modderfontein, Johannesburg, Gauteng for approximately the past 10 years, which is my current residence where I stay with my husband and my daughter. The property is a rental property. Prior to this address, I was resident at Highway Gardens for a period of approximately 10 years. I am married to Premila Shunmugam, a South African citizen who has also resided in South Africa his entire life. I have been married to my husband since 1988. My husband was retrenched 3 years ago, which left him unemployed and for the past 3 months financially dependent on me. I have 2 children who have both attained majority. My husband is unable to find employment, being a pensioner, and I am currently the sole breadwinner. Then, Your Worship, without dwelling on the merits of the matter, since same is to a large extent for these proceedings irrelevant, I will briefly deal with the employment history of the accused person, work history. I am the sole director and shareholder of a legal entity, namely Silver Touch Travel and Events Pty Ltd, since 13 June 2015, and which entity is the subject matter of the counts raised herein. At all material times, the aim of Silver Touch's business was event planning, specializing in tailored events and to provide services in the travel industry. I was previously employed by Merck Pharmaceuticals, heading dealing with assets and income. I do not own any movable property or vehicles. I own furniture and household equipment to the value of approximately 200,000 rand. My gross monthly income amounts to approximately 15,000 rand per month, which I use mainly for household expenses. Under the heading, the alleged incidents. At this point in time, I have not been granted access to the police dockets. I am therefore unaware of the evidence available to the National Prosecuting Authority to prove the charges against me. I am aware that the counts against me in this division of the Honourable Court are 3 charges of fraud for the amounts of numerically R145246, R174500, and R09999. I have been advised by my legal representatives, which advice I accept as correct, that as an accused person, I have in terms of Section 55(3) of the Constitution, the right to a fair trial, which inter alia includes the right to be presumed innocent, to remain silent, and not to testify during the proceedings. But due to the special and extraordinary circumstances of the case, I wish to in due course ventilate before the above-mentioned Honourable Court. At this stage of the proceedings, I'm not sure whether the NPA will centralize the criminal cases for hearing in one area of jurisdiction. If it is done, it is anticipated that this might take a substantial period of time to get the necessary authorization to do so. In light of the circumstances of the cases, it is my intention to plead not guilty to the counts which the NPA may formulate against me. I say this because I believe that I have a valid defense that any counts which might be raised against me. Previous convictions. My legal representatives have explained the provisions of Section 60(11)(b)(a) of the Criminal Procedure Act to me. I make the following submissions in this regard.
It should be the provisions of Section 60, subsection
11,
capital B.
Capital B(a). Indeed so correct. I'm indebted to the court. Thank you, Your Worship. I make the following submissions in this regard. During 2006, I have been convicted of an offence of fraud for approximately 300,000 rand, and as far as I can recall, was sentenced to a suspended sentence with a fine of 50,000 rand. The loss suffered by the complainant was settled in full. I am aware of the criminal investigations other than the Vierdabrug matters pending against me at the aforesaid police stations. I have been formally charged against my arrest in some of those charges, and I have not been released on bail pending any criminal charges to be brought against me. Section 64A, read with Section 65 of the Criminal Procedure Act. I undertake not to make contact or communicate with any of the state witnesses, and subsequent to their and request that their identities be disclosed to me to enable me to purposefully not make contact with state witnesses. I have not made any threats or any threats of violence towards any person. I do not harbor any resentment against any specific person, and I have no disposition to violence and have no history of disposition at any to in Schedule 1 of the Criminal Procedure Act. Accordingly, I submit that there is no likelihood that if I am released on bail, that I will endanger the safety of the public or any particular person, or I will commit a Schedule 1 offence. Section 64B, read with Section 66 of the Criminal Procedure Act. I respectfully submit that I have no intention of leaving the Republic of South Africa and are tied to South Africa by family, business, and occupational interests. None of my direct family members have immigrated and are or permanently resident in another country. There is no intention on my part to immigrate. I have not applied for visas and/or work permits to immigrate to another country. I am in possession of a valid passport, but no visas. I am prepared to hand over my passport to the investigating officer if the Honourable Court requires it to be done. I have dealt in detail with my assets and income above and request that this information is read herein as if specifically recorded herein. I have no intention of fleeing across the borders of the Republic of South Africa or in any way attempting to evade standing trial on the alleged counts. I concede that the counts to be levelled against me is of a serious nature. Notwithstanding this, I have no intention whatsoever to attempt to evade any criminal trial, as previously stated. I am unaware of the contents of the police docket, and I am therefore unable to ascertain the strength of the state's case against me. That having been said, I am prepared to submit myself to any bail conditions which may be imposed by this Honourable Court. In conclusion, therefore, I respectfully submit that there is no likelihood that I, if released on bail, will attempt to evade my trial. Section 64C, read with Section 67 of the Criminal Procedure Act. As I As I have advised previously, it has never been my intention and it remains my intention not to communicate with state witnesses. I believe that any evidentiary material which the state requires to prove any of the alleged counts to be formulated against me is in the possession of the prosecution and or the SAPS, and I accept that such evidentiary material is safely guarded. At this point, I am not aware of the existence of any evidentiary material which I could conceal, and should I become aware of such evidentiary material, I will certainly not conceal or destroy such material. I am not aware who the witnesses for the state are or whether they have made statements and or agreed to testify in the matter. To ensure that I do not communicate with any state witnesses, a list of the state witnesses should be made available to me by the state. I respectfully submit that there is no likelihood that I, if released on bail, will attempt to influence or intimidate state witnesses and or that I will conceal or destroy evidence. Section 64D, read with Section 68 of the Criminal Procedure Act. As previously stated, during 2006, I have been convicted of an offence of fraud. I have not been released on bail, pending any charges to be brought against me or formally charged with, and I am not on parole. I did not supply any false information to the investigating officer at the time of my arrest, and I am not supplying any false information at these proceedings. Consequently, I respectfully submit that there is no likelihood that, if released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. Section 64E, read with Section 68 of the Criminal Procedure Act. I respectfully submit that should I be released on bail, my release will not induce a sense of shock or outrage and will not disturb the public order or undermine the public peace or security. I further submit that my safety will not be jeopardized by the release on bail. Section 69 of the Criminal Procedure Act. I respectfully submit that the interests of justice do not require my incarceration. This is so inter alia for the following reasons. I understand that the counts to be formulated against me is serious, but the facts of this case differ substantially from a normal fraud scenario. Given the complexity of the nature of the counts to be investigated against me, the possibility of centralization of the counts, I am informed that a prolonged period may lapse before this matter is brought to trial, and I submit that such delay in completion of the investigation is not due to any fault on my part. I submit that as a result of the above, if I am detained, I will further be impeded in the preparation of my defence. Section 6011B of the Criminal Procedure Act. I respectfully submit that based on the facts set out herein, the interest of justice permits my release on bail. There is then further general remarks under the heading General, starting at paragraph 45. With the assistance of my family members, I am in a financial position to pay bail in the amount of 25,000 Rand or in the amount as advised by this Honourable Court for the purposes of securing my release on bail. I am on chronic medication for hormone regulation during menopause. I am also diagnosed with a medical condition of osteoarthritis, which is a medical condition causing pain and stiffness and reduced movement in my spine. I use inflammatory medication to relieve pain symptoms. I have cooperated with the investigating officer when he requested me to report at the Vierdabrug SAPS to hear my side of the story. I have reported to the investigating officer on Monday, 8 December 2025. I have been interrogated by disgruntled complainants in the presence of the investigating officer who was not satisfied with the outcome and therefore arrested. I have no reason to not stand my trial, and I am confident that I will be acquitted on all the counts should the matter go to trial. I will be severely prejudiced by my incarceration, balanced against the fact that I do not pose a risk to the state should I be released on bail, and that I will stand my trial. Signed originally by the deponent, being the accused person in these proceedings, and also duly commissioned. I beg leave to hand same up to be marked Exhibit A in the bail application.
Mr. Korodon. Mr. Erasmus, she says
Prior 2006.
can I have the case number on the affidavit? Mr. Korodon. The case number is capital A.
May it please you.
What 908 stroke 2025.
Thank you, Your Worship.
Madam, be informed if you confirm the content of the affidavit and agree it being used in support of a bail application, it may be used against you during a trial. Do you understand? Do you confirm the content of the affidavit? Do you agree to the affidavit being used in support of a bail application? Be informed further, should it subsequently transpire, the information contained in the affidavit about previous convictions and pending cases is not the whole truth. You may be tried, if convicted, you may be sentenced to 80,000 rand or 2 years imprisonment. Do you understand? Do you confirm what is written in the affidavit about previous convictions and pending cases? Affidavit is marked Exhibit A. Mr. Erasmus.
May it please you, Your Worship. Your Worship, in considering this bail application, it might be sensible for the court to just take a step back and consider the holistic history leading up to this bail application.
Remember, we are not there yet, Mr. Erasmus. At this stage, I expect you to make an indication to me if you are presenting any further evidence or if it is the applicant's case.
That is the application, Your Worship.
Thank you.
May it please you.
Mr. Maruma.
Debra has a PS CAS 432 stroke 11 stroke 2020. I'm Mari Martin Malapela, state under oath. I'm a sergeant in the South African Police, 17 years service legal representative advised other victims that all communication, they will be responsible to answer all questions on behalf of the accused. Whether the victims, the communities were consulted regarding this application, the IO wrote the victims are very furious using that bail be granted to the accused person. The accused will not be in a position to interfere with investigations because the accused was warned during interview not to have any contact with the IO himself. I wish court to take note of the following additional factors. The accused got 24 positive cases opened against her, and the company Silver Touch events and traveling from different police stations and around other provinces. Other investigating officers are also preparing to charge the accused with fraud cases. Your Worship, whether the accused person is a flight risk, the IO wrote the accused during telephonic interview. She told me that she relocated and refused to give current address, and it was for this reason that she is in fear of all victims and to secure her family. I oppose bail for the following reasons. There are many pending cases against the accused. Victims argue against the release of the accused person on bail. The accused is also in fear of victims, as she alleged that they threatened her. She is a repeated offender of fraud. If bail granted or released on warning, I wish court to impose the following conditions: that the accused must surrender her passport, she must not relocate to other provinces and countries, not to communicate with victims, and to sign at the nearest police station. The IO appended his signature at the bottom of the affidavit, dated the 18th of December 2025, and is duly commissioned. Your Worship, may the read affidavit be handed in according to Exhibit B of record.
Exhibit B.
Your Worship, that IO Martin Monari Malapela states under oath in English, I'm an adult male employed by South African Police as a police officer. Pierdebrug SAPS. Stroke 11 stroke 2025, cast for 33 stroke 11 stroke 2025, Douglas Dale cast for whereby state counts of fraud. During my investigations of this matter, I noticed that there are 37 cases opened against accused from different police stations, and they are busy charging her on the same matters of fraud. And attached is a list of cases reported and case numbers. I don't have access to the reported cases due to limited station out of district. The other investigating officer for these cases are arranging to charge the accused person on those matters, and including the matters that are outside this court's jurisdiction. I received calls from different investigating officers who confirmed that they are investigating the same matters, or rather similar matters, whereby accused Premila is the suspect. Currently, the investigation is not complete. There are still outstanding cases as well as evidence. I checked the accused's profile with the LCRC and found that she was guilty of fraud on case 321/03/2006, SAP 69 attached. I know and understand the contents of this statement. I have no objection in taking the prescribed oath. I consider the prescribed oath to be binding on my conscience. I appended his signature, Your Worship, and this affidavit dated today, the 17th, or yesterday, the 17th of December, 2025. May it be handed in accordingly. Exhibit C.
Exhibit C.
Your Worship, I do not have any further evidence to lead.
Mr. Erasmus.
I please the court. I've listened to the address by my learned friend to respond as follows. As Your Worship knows, there is a presumption of innocence, and in this regard, I wish to refer the court to Rambogen.
S versus
Rambogen. Do I need to give the full citation for the record, Your Worship?
I will appreciate it.
1985, bracket 3, close bracket, SA 587, bracket capital N, close bracket, N. In this matter, Your Worship, a full bench of the Natal Supreme Court referred with approval to the recognition of the presumption of innocence in bail applications. And in this approach was echoed by Milner J.P. in S versus Rambogen 2, when he referred to the accused ancient and fundamental rights to bail, and in Twahi versus Minister van Justitie, the full citation for purposes of the record is 1986, bracket 2, close bracket, SA 101, bracket, capital O, close bracket. A full bench of the Orange Free State Supreme Court observed that every person awaiting trial is potentially innocent, and unnecessary restriction of the citizen's liberty goes against the grain of all civilized perceptions of justice. Your Worship, in this instance, the numerous charges referred to by my colleague, which would appear is the only reason why the accused person may not be released on bail, is at this point in time only charges. The accused has not formally been charged with those alleged charges, and this court is, in considering this bail application, saddled with 3 charges of fraud emanating from the Vierdabrug SAPS. The question must be asked, Your Worship. Since this court is a regional court, the necessary jurisdiction to consolidate all of these charges, was the initial arrest on when the accused person Your Worship, the accused has taken this court into her confidence with regards to the fact that she is of ill health, which requires chronic medication. The accused is a 56-year-old grandmother. And the accused has since been approached by members of the SABC, not relocated. The accused husband is in court. He can testify to the primary residence of the accused, which has in any event been confirmed by the investigating officer. I do not intend to belabor the point unnecessarily, but it must be borne in mind, Your Worship, that for all of these charges to come to fruition, whilst the accused is presumed innocent and has the right to be released on bail, and as will be argued by the defence, is a suitable candidate for bail, with strict bail conditions to be imposed, it will unnecessarily impugn the accused's right to freedom and liberty whilst being presumed innocent. Your Worship, the point is taken that the emotions are running high, given the media presence in court today. But this is a bail application as any other. The objective facts need to be weighed. I repeat my submission that this accused person is charged with fraud, which is not a crime of a violent nature. The accused has a set address. The accused will be forfeiting her passport to the state. And will also, within the court's direction, report to the closest police station to her residence, being the Edenvale SAPS, every Friday between the hours of 5 and 7 o'clock, or as the court may direct otherwise, in order to ensure that the accused stands her trial which she has told the court by way of affidavit she has a defence for. Your Worship, it is on this basis that detaining the accused person ad infinitum, pending the 57 or 24 charges or whatever it may be, is not in the interest of justice. The scales in this regard do favour the accused person's release on bail, subject to stringent bail conditions which this court may impose. And perhaps it might be sensible to give the state an opportunity to consolidate all of its charges, because there will also, for purposes of appearing in court, there will be overlapping court days. Your Worship, my final submission will be that the accused is a sensible candidate for bail being granted, and unless there is anything else from the court, that is the submissions on behalf of the defence. And apologies, Your Worship, the amount of bail may be increased within the court's discretion in order to ensure that the accused person duly stands her trial. May it please you.
My concern is the indication by the public prosecutor that
I would submit that it is not necessary to arrest her because they can subpoena her to appear in court.
thank you. Mr. Malu.
Court pleases, Your Worship. Your Worship, this is bail 6011B, where the onus is on the applicant to show on balance of probabilities.
Not 60, 11 small a.
6011B.
Because 6011B is the bail application under Schedule 6. And why we pay us this bail application?
Your Worship, this is Schedule 5.
So
And it's a 6011B. Correct, Your Worship. Your Worship, let me reiterate. This is bail application in terms of Section 6011B of the Criminal Procedure Act, where the onus is on the applicant to show on balance of probabilities that interests of justice permit her release on bail. There is nothing on the part of the respondent that upon which this application is contested is that the applicant before court is a repeated offender. The offense, rather the previous conviction that she has to her name, it's fraud of 2006. Your Worship, it might have occurred in 2006, but it still forms part of her criminal history. She hasn't brought any application for expungement thereof. And the IO in his bail affidavit made mention of pending cases that the applicant has. Although the said bail affidavit did not contain the details of those pending cases, but in his supplementary affidavit, Your Worship, although the very same supplementary affidavit does not detail, but it makes mention of the number of cases pending against the applicant, which is 37 in number. And below that paragraph in his bail affidavit, he made mention of 24 cases. Therefore, Your Worship, on this basis that she has previous conviction of similar nature, pending case similar to the one that she applies to be admitted to bail with, I submit that she has a propensity or tendency of committing fraud or fraud-related cases. And if she were to be admitted to bail, there is a likelihood that she may stand before court on a Schedule 1 offense or a fraud case to be particular. Therefore, Your Worship, this is the ground upon which this application is contested by the respondent. And Your Worship, my colleague was saying we have a weak case against his client. That's not true. The evidence that we have against his client is overwhelming. Hence, we have multiple counts coming out of this jurisdiction. And I also brought it to his attention this morning that there are investigating officers from other jurisdictions who are likely to arrest the applicant should bail be granted to her this morning, Your Worship. Therefore, Your Worship, finally, I submit that we have multiple victims of fraud who suffered in the hands of the applicant before court, who are in the gallery. Some are pensioners. They lost their hard-earned money. Therefore, Your Worship, I submit that the applicant failed to tilt the scale in her favor, that interests of justice permit her release on bail. May bail be denied, she be kept in custody until the matter is finalized or until new facts develop. Court pleases, Your Worship. I'm done unless if court wants me to address it on something else.
I think, okay, Mr. Marumo, if you look at section 60, subsection 4, A to E,
Yes.
can we say the applicant is saying to
Your Worship, on the IO did not detail what pending case or cases are. Comes to an affidavit saying there are 37 cases which the applicant may be arrested for or charged for. But there is a previous conviction of 2006 of fraud registered against the applicant before court.
If I understand the state submission correctly, then it is that there is a likelihood that if bail is granted, he is likely to commit a Schedule 1 offense.
That's my argument, Your Worship.
And then this other,
Okay, Your Worship, can I deal with the allegations of chronic illness which my colleague made? My colleague made mention of chronic illness suffered by his client. But I did not hear my colleague saying I submit a medical certificate to prove that indeed my client suffers from such chronic illness. Although I know that this bail application is enough to allege, but my colleague should have supported this allegation with a medical certificate. So nothing was submitted. Your Worship, that's all, unless if court wants to hear me on something else.
these other cases, Mr. Maruma, that you have mentioned, will we be correct to attach a tag of pending cases to them, despite the fact that the accused said that they had been charged on those cases?
Your Worship, I admit that accused wasn't charged with those cases, and I engaged the IO to amend that part so that I was anticipating court to engage me on that part. So, but the IO opted to leave the part as it is.
So,
Because strictly speaking, if that was, or rather the 37 cases the IO made mention of were pending cases, the IO should have clearly stated in which courts they are pending, the next court dates, but there is no such.
so the state agreed in the light of the fact we don't have that information, they cannot be labeled pending cases.
Your Worship, I concede. I have to concede.
Thank you, Mr. Maruma.
Court pleases, Your Worship.
I'm not in a position to hand down judgment today. I'm going to postpone for judgment. My first available day is 23 December.
Might please the court, Your Worship, that is suitable.
Mr. Marumo.
It suits the state, Your Worship.
Matter is remanded 23 December 2025, back to court 16 for judgment in custody.
Court, please, Your Worship.
That concludes my role, Your Worship. I will
You are
excuse.
excused, Mr. Erasmus.
Please, Your Worship. Your Worship, may we have a short adjournment so that